Assembly Business Order of the Day Number 1, Legal and Constitutional Affairs Committee report on the inquiry into voluntary assisted dying in the Northern Territory. Continuation of the tabling statement.
Member for Fong Lim.
Thank you, Madam Speaker. Continuing from where I finished before lunch, recommendation 17 of the report sets the standard for a doctor who will make an assessment on voluntary assisted dying. And the nomenclature becomes increasingly important for us to recognise in this House as we move forward to explaining to the public how VAD will work in practice. So it's really a two-stage process, and the first stage is to have what we regard in the Australian VAD model as the coordinating practitioner. So recommendation 17 specifies that that coordinating practitioner must assess whether the person is eligible and meets all of the eligibility criteria. Their recommendation 18 is about the second doctor. And again, this is the clear point about the fact that the VAD process in the Australian model is rigorous and it requires multiple checks and balances in order to make sure that VAD is not used or abused in the wrong way. So recommendation 18 is about the consulting practitioner, again a medical practitioner. And the key thing with the consulting practitioner is, it's confusing, I appreciate, but the consulting practitioner is not a consultant practitioner. There is a difference in nomenclature there. So two people who are accredited medical practitioners of equal standing, it doesn't require that the second one is a higher authority or a specialist, a consultant as it were, has to sign off on that process as well to be able to determine whether somebody is eligible to be a candidate for VAD. Now, recommendation 19 is again about making sure that that assessment process involves the discussion of a plan for administrating the VAD substance further down the track. And 20 is about the referrals process and the duties, because it is the case that things happen, things change, doctors who sign into the process may be subbed out of the process, and if and when they are, it becomes necessary to make sure that we don't frustrate the intentions of people who are terminally ill and suffering and are unable to otherwise complete their VAD service. So there is a mechanism within this as well for referrals, as it were, such that a coordinating practitioner or a consulting practitioner are able to refer their work or their role to another person if so required. Now, these are the kind of nooks and crannies of the law that are required that are not fully countenanced by the public when we're just talking about, do you support VAD, yay or nay? Now, it is true that once upon a time the rights of the terminally ill had essentially set up a standard whereby two separate medical practitioners could make a determination about whether or not somebody would be a fit candidate for voluntary euthanasia. But at that time in that bill, the system was actually more cumbersome in the sense that there was a requirement in the Rights of the Terminally Ill Act for a psychiatrist to have to sign off on whether or not a terminally ill person should be a viable candidate for VAD. Now, even the proponents of the original Rights of the Terminally Ill Bill and Act would now argue that that was an unnecessary step that we did not need to take. And so, again, it's a clear example of where the world has moved on and the law has moved on and the Australian position has moved on, such that it is now necessary for us to work within the modern paradigm and make sure that we have the checks and balances that are required within the system to provide equitable access to voluntary assisted dying, should we so choose to legislate for it, but also safe access and practical access. Recommendation 21 is about eligible witnesses for the formal request process. So once two doctors have signed off on somebody as being an eligible candidate, there is still a process to have to seek formal request, and that must be approved in an approved form and signed by the patient in the presence of two eligible witnesses. And the person must certify that they're making that request voluntarily and understand the process that they're agreeing to. In 22, the recommendation makes it clear that if somebody cannot sign those documents, then they can do so with someone else's assistance. That person, though, can't be the coordinating or the consulting practitioner or one of the two witnesses. So again, these are the standardised checks and balances now that are embedded into the system. So we have to be able to provision for a mechanism that will allow people to be able to access VAD, but that we know cannot reasonably be expected to be abused. And that is exactly the situation we would face if we were to adopt a more lenient strategy. Recommendation 23 prescribes the eligibility requirements to act as a witness. Again, that somebody must be 18 years old, that they cannot be a beneficiary under the person's will, or one person can be, one person cannot rather, and that likewise the coordinating and consulting practitioners and whoever else should not be permitted to witness the formal request. So clear checks and balances to provide for a safe system for people to be able to be part of or opt out of. On 24, we have provided something novel that is not provided in the rest of Australia. So again, this is a key departure from the standard in the rest of Australia, and that is that we are providing protocols now to be able to do things via video, because we recognise that there are segments of our population that have lower literacy, that have lower capacity to be able to provide written consent. And not only that, we recognise that people who are terminally ill in places that are far-flung and away from urban centres may require assistance to be able to provide robust consent. And so video protocols are now embedded for the first time, which is not something that is provisioned for anywhere else in the country. Now, it may in fact be the case that video consent is a more preferable option to written consent in a number of instances when you think about the Northern Territory context. But notwithstanding, we have provided for, in the recommendations, formalities that we believe should be satisfied, including that any video includes but is not limited to the coordinating practitioner being present in that to witness it, the person clearly identifying themselves and who they are, and the person clearly making declarations to the effect that they are providing their consent. Providing consent is difficult enough when you are very sick and very ill and very remote, let alone if English is also not your first language. And we know that in the Northern Territory, a huge number of people don't speak English as a first language. Some of them are from culturally and linguistically diverse communities. Other people in Indigenous communities may be speaking English as a second, third, fourth, fifth language. And so 25 is where we begin to discuss interpreters that are required to certify materials, and that certification requirements, the interpreter must also be a qualified translator when required. On 26, we haven't adopted an arbitrary timeline, but we've adopted the standardised timeline between phases of requests. There is essentially 9 days of what you could otherwise call a cooling-off period between making a first request and then making a formal request. So things can't just happen like that on a whim or by accident. And that is a really important cooling-off period. And what was brought up regularly and consistently by the committee out in community was, once I've made a decision to start this process, can I back out? Absolutely. At any stage you can back out. At any stage up until administration. You can make a first request, you can have 2 doctors sign off on this, you can arrange for administration, you can have practitioners come to visit you, and you can change your mind on the day. There is nothing to say that people should not have choice in this system. And that's been the guiding principle for our committee on this whole process, that we want to be able to provide for access to VAD, but we want to make sure that anybody, whether they're in an institution or an individual, has the option to be able to withdraw from the process as well without fear or favour. And that is a really important, unique principle that we are moving further on than the rest of the country, in fairness, including with respect to the notion of cultural safety, which I shall come to later. Recommendation 27, again, provides some of the accreditation requirements for interpreters, because one thing that became exceedingly clear while we were out and about is that, just like everything else, we've got a shortage of interpreters. In many places, it is extremely difficult to find interpreters who are conversant with local languages, who are not also family members or connected to people. And so it is extremely difficult to find the right interpreters who are sufficiently and suitably accredited. And that is why, under Recommendation 27D, we have provided for the review board being authorised to be able to overrule the requirements for meeting the minimum requirements when no other suitable interpreter is available. And that's a practical reality. There are going to be instances when you're not going to be able to provide language services, translation services, interpreter services, unless you use people who have some sort of interest in the sick party. And so recognising the pragmatic reality of the paucity of interpreters in the Northern Territory is extremely important. As a tangential matter, it hasn't made it into our report, but we note that standards on accreditation for interpreters and for translators have changed in recent years. And in an effort to raise the bar, we have actually limited the pool in some ways of people available to help out, particularly in the bush, on these issues. Recommendation 28 is again about transfers at the request of the patient, because the coordinating role, practitioner's role also needs to be able to be provisioned to be able to be transferred. 29 is about telehealth, which is something that has gotten, again, really sort of casual consideration without detailed consideration necessarily in a lot of the Northern Territory. Now, if you take the time to go through our many hours of witness testimony, you will find that everywhere we go, we ask questions about, tell us about how telehealth works in your particular place. Is it working? Is it not? And the reality of it is we found that there are significant deficits in the use of telehealth. In some places, the connectivity is just not good enough. In some places, the hardware and infrastructure isn't good enough. In some places, there aren't suitable translators or interpreters, even if you have got working infrastructure. But that's not everywhere. There are a number of places where we learned that telehealth does work exceedingly well. And the medical profession has, by and large, through the Health Department and the AMA, made it clear to us that they would like for telehealth to be provisioned for, to be used in VAD. And in other states and territories across the country, increasingly, there are calls now to allow telehealth to be used as part of the VAD process. However, at the moment, telehealth is not authorised under the Commonwealth Criminal Code 1995 in relation to incitement via a carriage service. So, just the same way you can't use technology to incite someone to suicide through other means, you can't actually use telehealth in this space. Now, it's a grey zone, and the reality of it is that some components of the VAD process are being subtly used in a grey zone in some jurisdictions. Our thinking at this stage is that we have provision for, if and when telehealth is more widely used, we could use it too, but in the first instance that VAD should be an in-person experience, an in-person process as a default position. On recommendation 30 about administration, we make it clear that people must make clear and unambiguous decisions about administration. And on recommendation 31, we recognise something that people really struggle with in relation to whether or not administration must be supervised or not. And the fact is, that's a very difficult question that we spend a lot of time thinking about. And in the Northern Territory context, we came to the consensus position that we want to not frustrate people who may be in remote areas, may be in a cattle station, may be somewhere far-flung, may choose even to have self-administration in an urban setting and not necessarily want a doctor present for the process. And there are additional complexities when somebody is self-administering. You have to think about how they're going to access the substance, how they're going to take it, what will happen after the fact. And that's why there are very clear, delineated rules for self-administration versus practitioner administration. And so what we want to do is support people to make choices again. And so a person who makes self-administration decisions may still request to have a healthcare worker present, but that healthcare worker is permitted to assist in the process but not permitted to administer in the process. And that's a clear thing there, because we're trying to offer people the option to have support when they want that support in their final stages. Not everybody has the benefit of being surrounded by friends and family and loved ones, and some people will elect to want to have a healthcare worker present based on testimony that we have from other parts of the country. Recommendation 32 is again about the self-administration situation and notes that you require a contact person. This is the fact that somebody has to accept legal obligations to be able to provide information to the review board about the patient and what's happened. Somebody's going to have to, in the ordinary course of events, potentially collect a substance, return the residual of the substance, notify the relevant authorities. And so we have provided, again, a standardised prompt, 2 working days to provide that information, for the contact person to have to provide that information to try and keep the wheels moving. Recommendation 33 makes clear that that contact person is legally permitted to receive, possess, handle, prepare and supply the VAD substance, but that they also have very explicit obligations to return unused substances, to report the person's death, to provide information to the review board as requested. These are the realities and nooks and crannies of VAD that people need to understand. Recommendation 34 is about the 2 business days again of notifying the review board. And on 35, we consider in detail what a prescription must consider. Because again, pharmacy has been a critical part of this that was almost overlooked in the early stages and became a curly question. And without wanting to derail all of what we're saying, there have been challenging situations in recent times when pharmacy protocols have not been followed perfectly, and it has led to people having to remediate, as it were. Now, for the most part, what we have is a clear situation where VAD has been used safely and effectively across the country utilising the Australian standard. But there are exceptions. And those exceptions are worth knowing about so that we enter this process advisedly and do not make mistakes that other places have made. And for us in the Northern Territory, what does that mean? What that means in practice is that we have probably 2 great hospital pharmacy setups in Darwin and Alice Springs that have sufficient robust controls to be able to house and safely store and dispose of pharmacological substances. And perhaps we don't want dangerous substances in locked boxes in other places that may not be as secure. So we have tried as best as possible to think through these possibilities. Recommendation 36, again, prescribes that we should consider definitions in the context of that space. Who should be an authorised supplier? Who should be an authorised disposer? Written information that should be provided to people to guide them on how to self-administer, to authenticate prescriptions, and, as I say, to return VAD substances along with guidance in that space. Recommendation 37 is about timely reporting to the review board, which is an extremely important part of this process for us. 38 is about practitioner administration decisions, and this is the critical decision again. Some people will elect to self-administer in VAD situations. We know a good number also choose to allow a practitioner to do that. And for that process to happen, you require eligible witnesses to practitioner administration, people who need to witness and certify in the approved form that the person was acting voluntarily, without coercion, and that the administering practitioner administered the VAD substance in the presence of that witness. Certifications also need to be provided to the review board within a couple of days for those processes. On 39, we note again, as with the 2 doctors making the assessment, the administrating practitioner can transfer their role to another practitioner. We don't want people to be frustrated in the process. We know that we have a paucity of options available for people who may engage in the service, but we need to at least provision for the most practical application of VAD. On recommendation 40, we note that the coordinating and administrating practitioner must notify the review board of the death of the person and that they died as a consequence of the VAD process, again within 2 business days. 41 is self-explanatory in relation to the cause of death certificate. 42 specifies again, consistent with the earlier recommendation on destigmatisation, that the underlying eligible terminal illness, disease or medical condition is what should be nominated as the cause of death. And 43, so as not to, again, unduly burden our coroner, as was the case in some other jurisdictions because of ill-conceived legislation on the front end, that a VAD death is not necessarily a reportable death for the purposes of the Coroner's Act. There is always the provision, of course, for things to be referred to the coroner as and when required, but it is not an ex officio default position. 44 is about the level of experience required by the people involved in this process. Now, nowhere in Australia has trainee medical graduates, involved in the VAD process, but there are other places that have varying degrees of expertise assigned to practitioners, medical practitioners. We have settled on the most common position that is also supported by the 2024 inquiry report, which is that medical practitioners must have at least 5 years of general registration or 1 year of specialist registration, in which case they essentially have the 5 years of general registration as well. Essentially, we're saying that people who are standalone doctors and able to practice without training wheels are allowed to make decisions about VAD. And that means that we can tap into our public and our private system by making sure that we have a decentralised model of VAD service delivery. 45 is about mandatory training. Even if you are a standalone doctor, you still must have completed the authorised prescribed training that the Department of Health CEO will have developed. So there will be mandatory training for people to have completed in order to make sure that VAD is delivered uniformly, equitably and safely. 46 notes that the coordinating and consulting practitioners can't be family members of the person requesting VAD or a beneficiary of the will of the person accessing VAD. Again, critical distinctions that need to be made on the front end. 47 is about providing, notwithstanding, flexibility in administration. Because once the decisions are made, once the difficult decisions have been made by doctors about whether or not somebody is an eligible person, we recognise that it is not necessary for a doctor to necessarily be the person who administers a VAD substance, but rather that an administrating practitioner could be a qualified medical practitioner, a nurse practitioner, or a registered nurse who has practiced in the nursing profession for more than 5 years. We say this because we know that it is nurses, particularly out bush, particularly out in communities, who have the close contact with people in their end-of-life care and potentially in relation to a VAD service. 48 again makes clear that, like with doctors themselves, administrating practitioners must have completed the standard mandatory training to be determined. Now, we have again advised, and we note in our testimony, that we could create economies of scale by working with other jurisdictions to find out what their processes are in relation to training. We don't need to reinvent the wheel on everything to do with VAD. And if we actually want anyone to be able to practically access it any time within the foreseeable future, we will need to be agile in relation to working with other jurisdictions to benefit from their wisdom, their experience, and potentially their training collateral. 49 notes that administrating practitioners, again, cannot be related, cannot be beneficiaries under the will of the person. And 50 notes that relevant persons involved in providing or supporting the provision of healthcare services who conscientiously object can do so. Now, on 51, this is a key NT-based consideration where you think about the people who can conscientiously object from the process. People who conscientiously object from the process are not just limited to a couple of doctors, not just limited to nurses. In the Northern Territory, we have a huge ecosystem of Indigenous healthcare and people who are essentially Aboriginal health workers and liaison officers by a range of different names. And under any of the standard legislation across the country, those people are afforded no specific protections or indemnities. And so we note that relevant persons involved in providing or supporting the provision of health or care services, which is a much broader category, should have the right to refuse to do any of the following: to provide information about VAD, to participate in the processes, to participate in administration, to prescribe or administer substances, to be present at the time of the administration of a substance. i.e., if you are somebody who is uncomfortable as a person who works in the Aboriginal health ecosystem with wanting to participate in this, you can step away from it and you will be entitled to do so on the provisions that we have championed within this document. 52 is about, notwithstanding the duty to refer and or inform for conscientious objectors. As we've made clear, you don't have to participate, but you can't actively block somebody who is otherwise terminally ill and requires access to information from getting to that information. So at a minimum, we say that the person must be given information about a healthcare practitioner or service that is likely to be able to assess them, as well as the contact details of the official government state-sanctioned VAD navigator service. 54 is about health or care entities, noting that that covers not just public and private hospitals, not just hospices, but also residential aged care facilities, nursing homes and other facilities. And in the Northern Territory, that's extremely important because if you go out to our places outside of Darwin and Alice, you've got a limited number of providers providing our aged care, our palliative care, our disability care, even primary health care on occasions as well. And some of those organisations are auspiced by entities that do not necessarily want to be involved in VAD. So we have to specify who is who in this very carefully. 55, again, is unique in Australia in that we have suggested in the Northern Territory that we essentially should extend the opportunity for institutional objection and allow it to be permissible, essentially. The committee recommends that health or care entities that object to VAD may refuse to participate in VAD. So for argument's sake, you have an aged care facility that is auspiced by a church, out somewhere out bush, if that entity is uncomfortable with VAD being something that they do within their premises, then they are allowed to make that choice. We are not compelling anyone to do anything that they don't want to do. But we make it clear in that process under 56 that that organisation, that facility should make clear to the people residing within that facility, this is not a VAD facility. This is not a place where we participate in VAD-related services. And that is an acceptable compromise in the context of rights for the people on the Legal and Constitutional Affairs Committee. They must advertise their position publicly. They must notify in the health or care entity, notify persons in the health or care entity, including residents and patients who wish to express or access VAD of their position, which we think is a reasonable compromise. 57 is about not blocking people at the door. Now, you wouldn't believe the stories that have come out in other jurisdictions of these things not being thought through, and you having a very sick person inside a facility that doesn't want to do VAD services, and then having VAD proponents, practitioners or advocates knocking on their door, trying to come through the front door, and essentially being blocked. And the scene that causes and the upset it causes for everyone. So it's extremely important that we make it clear what everyone's rights and responsibilities are in this regard. And in essence, what we have said is that the health or care entity must provide the person with contact details of the navigator service. And the navigator service then can help them. And they must allow reasonable access to the person at the health or care entity by a member or employee of the official navigator service. And in general, not hinder the person's access to information. Information should be accessible to all Territorians. 58 is about not prohibiting or preventing an employee or a healthcare worker on-site from initiating conversations. And again, we have gotten testimony throughout our witness transcripts of people who've made clear that previously they were caught in a bind where patients wanted this information and simply couldn't receive it. However, under 59, what is clear is that the relevant steps in the VAD process, the making of a first or formal request for VAD, the undergoing of a first or second assessment, the making of an administration decision, the administration of a substance, those are things that an entity can object from participating in. Recommendation 60 is the requirement to reasonably assist, though, when you've got somebody who is extremely sick, basically can't move around, is in a facility where they want access to VAD, but the facility doesn't provide it. All we have asked for in that instance is for the care entity, the health or care entity, to take reasonable steps to facilitate the transfer of the person to, and if required from, a place where the relevant steps in the VAD process can be carried out. Again, what we want here is to prioritise choice and voluntariness. 61 is where we move to establishing the VAD Review Board in the Northern Territory. And in 62, we make it clear that completed cases must be notified to the VAD Board. 63 is where the powers of the VAD Board are specified. And they are broad powers and important powers, but they must be clearly specified powers at the outset again. To monitor the operation, to review completed cases, to refer instances of non-compliance to potentially the Police Commissioner, the Coroner, the Aboriginal Health Services, any number of parties that are relevant, to collect, record, use and keep data so that we can learn from this process and maintain best practice, to report to the Minister or the CEO of the Department of Health in relation to the operation of the legislation, the Board's functions or improvement of the processes, to promote compliance, to set standards and to maintain continuous improvement. 64 notes that, again, there must be information provided at regular intervals to the coroner, including the number of completed cases. We do not want to bury the coroner in each bit of paperwork surrounding VAD processes, but coroners must be informed of the number of complete cases. 65 is about requesting information and the board's power to request information for the purposes of exercising its function from the CEO of the department and from treating practitioners, from contact persons, to maintain integrity in the process. 66 maintains that the board must act independently and in the public interest, and that they are, by default, not subject to direction from anyone, including the Minister, about how they perform their functions. Now, there is a logical tautology, an inconsistency in that, a circular piece of logic in the sense that if you have this embedded within the Health Department, then of course there are lines of reporting and sight that do blur and or become circular. But again, if you refer to the testimony from the 5th of September, you will find that the Health Department, when presented with the option, suggests that it is possible It would be unusual and not what has been done elsewhere, but it would be possible for us to use our existing health structures, our existing statutory powers under the Office of the Chief Health Officer to be able to administrate a review board with integrity and with separation still from the Minister and from government, as it were. 67 is that the board is to be provided with the resources reasonably necessary to do its job. Set the board up to fail, and you can be sure that governance will fail on VAD, as it has been tested in other places on occasion. 68 is about, on the recommendation of the Chief Health Officer, the membership of the board being assigned by the Minister, which includes people with sufficient experience to do the job, but also sufficient geographic and regional characteristics and spread to be able to reflect the NT community and its diversity. And to that effect, in 59, we have specified a minimum composition for the board, which is to say the Chief Health Officer or another delegated person by the Chief Health Officer, one member who has clinical expertise, including medical or nursing, one member who has legal expertise, but now importantly, one member who is an Aboriginal person in a position to provide and seek advice from First Nations peoples in relation to cultural matters, and one member who is also employed or a representative of an ACHO, an Aboriginal Community Health Organisation. We know that the service provision and model for care in the Northern Territory is shifting and changing away from entirely state-based provision. And so those ACHOs are really important to have some representation in that space. Now, that's not the total composition, that's the minimum composition. And those things may be prescribed and added to in the future by regulations and by the department themselves. 70 is, again, our clear expression of the fact that the Chief Health Officer should be the chairperson of the board. And the reason we made that decision was very, very, very specific, and it's because that Chief Health Officer position already has statutory powers, already uses existing structures, and it is not a huge ask for us to build an adjunct piece of work under the auspices of the Chief Health Officer to manage VAD and the review board, and that is what we think is a pragmatic way forward and a cost-effective way forward and a reasonable way forward in terms of safeguards. 71 provides for a deputy chairperson, and 72 provides that cultural safety must be a consideration in these discussions as well. And I note that the committee had a diversity of opinion on a range of issues, including this. But this is our consolidated position. This is our compromise position on everything. You will note that this is the first report in living memory that hasn't had a flood of dissenting reports surrounding it. And it's because across the political spectrum, the 5 committee members, ably assisted by the committee secretariat, did their best to find common denominator positions in order to progress the agenda of VAD for Territorians. 73 is the nuts and bolts of what happens on that board, the board administration. Inane stuff, but if you don't specify from the outset the term of the board, appointment of the board, vacations of office, conditions of appointments, proceedings, then they're not specified elsewhere. And we recommend those things should be specified in the legislation. 74 is about annual reporting to the Minister and the frequency of doing so. 75 is about how regularly the Minister must table a copy of the annual report to the Legislative Assembly. And that should happen in a timely and prompt manner so that this House is always aware of what is happening in the VAD space as well. 75 makes definitions in relation to 76, the reviewable decisions and eligible persons. 77 specifies that an eligible person can apply to LCAC to seek review of a reviewable decision. Now, that's an extremely important mechanism. We need bodies to be able to have oversight of appeals processes on eligibility and, quite frankly, if and when things go wrong. And so LCAC is the appropriate forum, notwithstanding that anything in the NT legislation affects nothing in the NT legislation rather, would affect the inherent jurisdiction of the Supreme Court to hear matters pertaining to VAD. 78 prescribes that the legislation should be reviewed 3 years after its day of commencement and every 5 years thereafter after the first review. And that's consistent with the Australian position again. Again, some people would like there to be just a continuous process of review, but quite frankly, we did not think that that was necessary. We think that we have enough information to set this up sensibly on the front end and for it to be operational within a couple of years, and then for there to be reviews thereafter. The review must consider, though, the principles set out in the legislation, the eligibility criteria, and whether the legislation is operating as intended. We say that because we know that things are likely to change in the VAD space around the country. Other jurisdictions are starting to look at reviewing their legislation, adapting things. It may be the case that by the time we reach a review stage, that we are thinking more broadly about principles, eligibility, operation again, and we may want to refine our processes. So embedding it on the front end is important to say that these are the things you should be looking at when we first do a stock take. There are, I note, a number of reviews happening around the country at the moment in relation to VAD processes, and we've learned quite a lot from them, and submissions have been made by some of those review boards to us as well. 79 is about the creation of new offences. Again, not things that you turn your mind to when you're thinking about do you support VAD, yay or nay. The fact is, when you create a VAD ecosystem, you create a series of opportunities for new offences to be committed. Some of those offences could be extremely serious, some of them could be more minor. Serious offences, though, would include things like the unauthorised administration of a VAD substance, inducing a person to request VAD, inducing a person to self-administer. Those are the horror scenarios that none of us, of course, want to see happen. But you must create serious offences in the legislation to account for those things from the very get-go of VAD. Likewise, to knowingly provide false or misleading information or statements or documents to the review board, those are also offences which must be created. And likewise, we need to create offences for non-compliance relating to procedural requirements by health practitioners or contact persons, for example, failing to return a substance within a timely timeframe. 80 is about liability and exemptions for participation in VAD, and we provide for the fact that a person will not be criminally, civilly or professionally as relevant be liable for assisting somebody with the VAD process, being present or acting in accordance with the legislation. 81 is the same thing but for health practitioners' indemnity, which is slightly different. Health practitioners will not be criminally, civilly or professionally as relevant liable for referring a patient who requests VAD services. 82 is about health practitioners or others, so the wider ecosystem of anything that could be a counsellor, an occupational therapist, a nurse, an Aboriginal healthcare worker, to basically provide them with the capacity to be able to 82, to be clear, is about refraining from administrating life-sustaining treatment. So again, people who would normally be professionally obliged to provide life-sustaining treatment under VAD circumstances, if they believe on reasonable grounds that a person was dying after receiving a VAD substance and that that person does not request life-saving treatment, they would not be liable for not providing that. Think about paramedics, if you like, in that context. 83 is about the fact that notwithstanding all of those indemnities for criminal, civil and professional liability, complaints are still possible. So you can still make a complaint to the relevant oversight body, whether that is the review board, the LCAC or the Supreme Court for that matter. And finally, miscellaneous provisions under 84, there are a range of, recognising, for example, that technical errors on a form shouldn't invalidate processes as they have frustrated them elsewhere on occasion, and likewise that the CEO of the Department of Health should be empowered to be able to establish an official VAD navigator service, work out who supplies and disposes of substances, work out what VAD substances themselves are going to be in this jurisdiction, approved information, approved training, approved forms. There is a huge body of work that needs to be done to provide the structure and the framework to be able to provision for VAD. Again, our position is that it would be prudent to work with other jurisdictions to try and license some of their collateral, if at all possible. But that will be a question that will be determined under 18 months of implementation, which is the focus of Recommendation 85. It is a standard process across the Parliament at the moment that legislation should be operational for implementation, across the country rather. It's standard across the Australian parliaments that there has been an 18-month implementation period after legislation has been enacted. That is why people ask us, for example, about the ACT, and the ACT numbers are still 0, because the ACT hasn't actually started implementing VAD in practice for patients yet. That will start at the end of this calendar year, at the conclusion of the 18 months of implementation timeframe. And finally, and very importantly still, Recommendation 86, we recommend that the government implement a culturally safe and accessible public information campaign during and after the implementation phase of the VAD campaign. Because one of the most consistent things you'll find in our witness data is people essentially going, quite honestly, I don't really know much about this, can you tell me more? And a lot of our witness testimony is about having an iterative discussion to explain to people what we're there to talk to them about, and them saying, we'd like more information as this develops and changes. So it will be an important job of the Department of Health to be able to maintain communications if they are indeed to oversee a VAD process after the introduction of legislation, which the government has at this stage committed to. Now, the drafting instructions, Appendix 3 of the document, as I pointed out, are the distillation of those 86 recommendations in many ways, and a very clear-cut blueprint. So you can get a digested form of many of these things by simply reading this, but you fail to see the context or the support for the positions. Instead, for the most part, what all of us are working with in and around this agenda and this issue and this parliament is pretty imperfect data. How many people support VAD? Do they support it in my community? What type of VAD are we really talking about? We are fast going to approach the situation now where it'll be incumbent on everyone in this House to seek answers to those questions, to make sure that you are able to say with conviction that I have made a decision on behalf of all of my constituents, or that I have made a decision that is representative of my constituents, or some combination thereof. There are, of course, limits to how much you can test people's opinion, and so running referendums on the drafting instructions is not the suggestion here, so much as to suggest that when there is a bill, that perhaps the bill should be the thing that people are tested on in relation to their yes-no answer. Or before there is a bill, perhaps we may be able to test some of the key propositions, like are people generally supportive of a requirement on prognosis being dispensed with in line with the ACT, as an example. Now, one of the things that I would have liked to have seen in the report, but that is not in the report in any form, is any mention of the limitations of the inquiry and the limitations of the research design. And the great irony of that situation is the fundamental limitation of the research design and the inquiry was time. The absence of time is why we also didn't have the time to talk about limitations and the things that could have been done better. And it is good practice, in my opinion, not just in academic research, but in works like this, to be able to acknowledge that we did not do everything perfectly. We simply could not do everything perfectly. The task that was put before us was significant, and the commitment collectively by the group was to advance the task as best as possible within the time allocated. Notwithstanding, on the 1st of September, the committee did, again, across party lines, all uniformly ask for extra time to present our final report a few months later. But the government asked us to provide it by the end of September, as it had initially intended, and we were able to achieve that. And that is a positive development, I think, and the right decision has potentially been made in that regard. But it has come at a cost, and the cost has been that we have had to compromise on process. We've had to compromise on every part of the process being perfectly executed. The only way that this VAD inquiry was ever going to get done and delivered was for us to multitask things. And so we had to wait until we had a consultation report before we could start thinking about where we would go out and about. We went out and about as best we could, but at the same time we were collecting written submissions, which we weren't able to read before figuring out where to go out and about. Hansard can only work so fast to process crazy numbers of transcripts out in the bush. And so we were waiting on those transcripts of proceedings to figure out what was happening before we could move forward again. Time was the fundamental limitation of the inquiry and the research design. It meant that not all processes were conducted with the rigour that I would have liked them to have been conducted with. Nevertheless, the important point to make here is that in spite of all of the limitations, in spite of a very short time frame, in spite of the pressures of the subject matter and having to do things in a compressed, pressurised environment, we have produced a very substantive representative data set from across the Northern Territory that adds huge amounts of value. And I don't seek to politicise the issue at all, but I will acknowledge the Chief Minister's remarks in that regard from earlier today, that what we have done is added knowledge to existing knowledge by recognising that, quite frankly, there was never full and complete and comprehensive data collection and consultation done out in remote Indigenous communities, in remote areas. Could we have done more? Absolutely. Would we have liked to do more? Absolutely. Would we like to do more in the future? Potentially. All of this is true. But notwithstanding those limitations, we were still able to get out to a very large number of places and speak to a very large number of people and receive a very, very large number of written submissions. Now, Madam Speaker, I brought along all 400 submissions with a view to talking about some of them, but in the interest of being sporting, I won't. I will note that the written submissions make for fine reading, and the important thing to recognise in the written submissions is this. Some are hundreds of pages long, and some are literally 2 lines long, but every one of them mattered to myself and to my colleagues who sat on this committee. And why I think people should go back to looking at them is because they explain reasonable objections and unreasonable objections, reasonable opinions and unreasonable opinions. There are some people who simply want to say point blank, I don't want it, that's it, that's all I have to say. Fine, there are other people saying, this is great, you should have already done it. Not super helpful, but adds to our body of knowledge, right? And all of those people deserve to be heard, but what we haven't been able to do, again, because of the limitations of time, is provide, for example, qualitative and quantitative metrics, pointing out how many of these things did we get to somehow squish into the final report? How many people actually got heard fully? I don't know if I'm draining power from the building at this point or what's happening, but Madam Speaker, is there any...
Run out.
Can I just proceed, or is that a sign from God? No. I'm just going... Okay, great, thank you. The written submissions are worth reading and not as daunting as they look, and there are some very complex, large, dense submissions. For example, submission 6 from Professor White before we appointed him as an expert advisor for ourselves is a long list of academic literature, which is extremely potent academic literature in and around this area. And there's hundreds of pages of that submission. Meanwhile, as I say, other things are one-liners, you know, yes, no answers. But it all matters, and I assure you, Territorians, if you don't see your name in a footnote in the report, it doesn't mean we ignored your submission. It doesn't mean that we don't think what you had to say is valuable. We read all of it. We read all of it, and everybody worked extremely hard to process it all as fast as we could to produce the best work we could within the limitations of time. What you will need now to progress the issue, Madam Speaker, I say to members of the chamber, is essentially survey data of your own. Everybody will have to go out there and test in some defensible, empirically justifiable, quantifiable way what support for VAT is in your community. Because I assure you, if people come out saying they are either for or against this proposition on the basis of whose door they last knocked on and not much else, somebody else is going to skewer you and be very unhappy. And this is really an issue of life and death, and it is actually worth everybody making an effort through whatever means you best can to survey your electorate. That may be through your newsletter, that may be through a phone canvass, it could be a digital survey line, it could be any number of things. But I encourage you all to start that process now, because existing sets of information that we have are extremely imperfect. None of them clearly spell out 99% of people are in charge of that, right? All we have is a set of polarised opinions, but we don't have good, robust data to really indicate what the level of support for VAT is across the Northern Territory in all places. And to that point, one of the fundamental things that I take objection to is the idea that all Indigenous people are the same, think the same, believe the same things. It's simply not true. And presented with the opportunity to express themselves, Indigenous people from across the Northern Territory, across the width and breadth of the Territory, as best as we were able to cover it, expressed a vast diversity of opinions. Many people are opposed to VAT and don't find it to be something that they culturally want to participate in. But there are others for whom, the majority I would say in our data set, there is very much a laissez-faire attitude of, maybe not for me, but I don't mind if other people have it, right? And then there is other testimony from people who are Indigenous, who are from out bush, who are from remote communities, who are not only for it, but even have had interactions with voluntary euthanasia in the past. Now that is extremely important testimony, extremely important findings, extremely important data that has not seen the light of day before and helps us understand that once again, we're all fundamentally human. Nobody wants to die a painful death. Everybody wants to be able to have a good finishing up. whatever that might look like. So what we've managed to produce is a substantive, representative data set that adds considerable value to our understanding of euthanasia, voluntary assisted dying, and the rich and nuanced data from witnesses is something that everybody should engage with to some extent to understand exactly what we have found out bush. Tell us the stories of what we found out bush. Well, again, I'm not going to be forensic about it, but I am going to point out some broad overarching highlights of what we learned in the places we've been to, because this is the rich qualitative data that is new, that really teaches us what it is might be suitable for the Northern Territory. Broadly speaking, we endeavoured from the outset to the committee, that is, to be essentially on the road for a month, and that's a significant undertaking commitment. All of the other committee members have families and obligations. I just have a garden that I'm killing. I had the least obligations, but everybody else gave up precious time from their children, their partners, their families to be out and about and engage all over the Territory, and occasionally at risk of life and limb. I won't tell the tale, but at least one of our planes, light aircraft, had to make an emergency landing in Tyndall. We were able to cover some, but not all of the Territory, but enough of it for this to be a representative data set. And in essence, whilst we definitely got off the beaten track, we still essentially focused our efforts in and around 4 primary locations, if you like. The first of those 4 primary locations is Darwin itself. And in Darwin, we were able to conduct testimony and hearings with public officials under perfect conditions, which is why we're able to get perfectly time-sensitive Hansard, ask deeper, more meaningful questions, have everything out into the public domain as quickly as possible. And to the very many people who have been reaching out behind the scenes, wanting the information, that is why that information was out first, for practical reasons, not for any nefarious purpose, to hide any other information. Thereafter, again, consultations we did in Darwin involved Aboriginal communities coming to us. So we started our process on day one by reaching out to the chairs of the former independent expert inquiry, but also to the heads of all the land councils, also to the head of AMSANT, because we knew that going out bush and consulting with people in remote and regional areas meant having the cooperation of people out there. And so we extended the olive branch. Now, for the most part, people didn't immediately leap at the opportunity to cooperate with our inquiry. But with time, as word got around that we were giving this a fair go across party lines to try and gather real information with, a Green, a member of the Labor Party and 3 members of the CLP, we got people coming to us. Representatives from Tarrantippi Homelands, Warramienga, Tiwi Mob, they made time to talk to us en masse from the Tiwis. Maningrida actually sent an entire delegation of people to us in the Parliament. We couldn't make it out to them, and they decided this was sufficiently important for them to make it to us. So any suggestion that these consultations were, not credible, I reject. These consultations were imperfect. These consultations were bush consultations. These consultations involved, trying to use technical equipment in odd circumstances and odd places, sometimes things not going exactly as they would as if we were collecting testimony in the parliamentary committee rooms and chambers upstairs in Parliament House, but they were credible consultations and they were geographically dispersed across the Territory and representative of the views of Territorians generally, not just Indigenous Territorians. Then there's sort of a second suite, if you like, of consultations that we did where we learnt a ton of things, which I consider the sort of community hearing consultations. Nooka, Borroloola, Barunga, Goombalunya, Papanya, Numbawa. Each one of those places is a separate consultation, each one of those involving day-long processes, each one of those involving multiple stakeholders. And we are indebted to the people in and around the Roper Gulf region, and in fact to the cooperation again that we received from the Leader of the Opposition in helping us to facilitate some of that. We are grateful for the bipartisan work we've done in this space, and we are grateful for the fact that we've been able to produce a report without any dissenting reports, and there is a reason for that. And it's because we tried very hard, under very challenging circumstances, to come up with a common denominator position. Not a lowest common denominator position, but a common denominator position. A third sweep of consultations, Madam Speaker, and an important one, is based around Alice Springs. Alice Springs is not Darwin. The centre is not the north. And all of what happens in the centre cannot be collapsed into the same basket. And we knew that from the outset. And that is why we spent considerable time talking to people in Aboriginal engagement, at the hospital, in palliative care, as well as to key protagonists in this situation, like the Australian Christian Lobby. We didn't shy away from having the conversations. The Old Timers Centre, the Baptist Church. We gained really, really valuable data in that sweep of things in and around Alice Springs. And then the final sweep of consultations, if you like, geographically, is focused in and around the Barkly, which I'm sure the member for Barkly will be delighted to hear. Tennant Creek, Barkly, Puka Puka, Disability Services, the Tennant Creek Mob, the Cattlemen's Association, Tennant Creek Hospital. I sadly wasn't able to participate in the last day of consultations because I myself ended up in the Tennant Creek Hospital after getting food poisoning at short notice. But I can vouch for the fact that it is a fine facility and we collected data in every conceivable way, including in person, as it were. Now, what is it that we learnt out there? Well, as I said, I really would love to quote aspects, forensically point things out. You could write an entire PhD thesis on the data that we collected, supplementary to the report that's been presented, to explain the rich and nuanced findings of the bush in relation to voluntary assisted dying. But I'm just going to provide some signposts for other people who may wish to explore further going into the future. On the 5th of August, we had an initial hearing, a public hearing, with the AMA, AMSANT, NT Health, which really set up the foundations for our inquiry. What were the plans from our health providers for VAD? Did they have a plan? Could they implement this? What was it really going to take? And what we discovered very quickly was not that they had no idea, but that we were in a chicken and egg situation here, of them saying, you tell us what the law is and we'll tell you if we can do it. And us saying, you tell us what you can do and we'll try and make a law that actually works with that. And so it's been an iterative process for us to establish the right set of recommendations and tools to be able to potentially provide a framework for VAD moving forward in the Northern Territory. The testimony from that day is really important, as are the written consultations that come, the written submissions that follow it from the same providers. But equally important for us on that first day, and deliberately chosen, was public testimony from private citizens. And one of those private citizens we spoke to was Miss Judy Dent. And as most people who are involved with voluntary assisted dying will know, in the Northern Territory, Judy Dent's husband was the first person to avail himself of an assisted death as a terminally ill person under the Rights of the Terminally Ill Act back in 1995. And so it was important for us to hear from Miss Dent, it was humbling for us to hear from Miss Dent, and it was necessary for us to hear from Miss Dent to remind ourselves that this is not just a technocratic puzzle, much as I might be making it seem so through my remarks to some extent, but this is about human beings and people and a good life and a good death. Humanity, compassion, the greater good, understanding that people have different perspectives and that they are entitled to have those perspectives. So the 5th of August was an important day in terms of establishing our setup. And then, as I say, in Darwin, we had two other extremely insightful sessions, one of which was with the Tarrantipia Homelands Aboriginal Corporation, with a number of significant and senior people on a call with us from the Tiwis, speaking to us essentially in detail about dying on country. If you want to know about what people have to say in that space about dying on country, there is a ton to be learned from that consultation. The Maningrida delegation that flew in to meet with us gave us some of the best testimony we had about the positives of telehealth. We had heard in a number of places that telehealth, frankly, didn't work very well, couldn't be used effectively in criminal justice proceedings, and that shouldn't be used in medical proceedings at all. But we learnt that in Maningrida, albeit a large and well-resourced community, telehealth does work really well in many regards. And that gave us hope for the fact that telehealth could be part of this equation still, and we shouldn't just write it off completely. So the positives on telehealth and service provision were things that we learnt about through the Maningrida process. At the very, very end, we wrapped up our consultations in Darwin on the 5th of September again, on short notice, by asking the AMA and the Department of Health to come and speak to us again about how to meaningfully deliver VAD. And I can't thank those witnesses enough again for their generosity and their honesty in being frank with us about the actual nuts and bolts of VAD and what it was going to take to make it work in this place. And so I don't want to quote extensively from this, but it's a question that comes up all the time. So from page 20 of that testimony, I'm quoting from my own words here. I need to, for the sake of the record, just get this here. Notwithstanding that service delivery models will evolve, as you indicate in your written submission, as we have discussed today, what we are looking at, if we have a core centralised service in terms of practical impost, in terms of time and resources, is something in the order of an increase of palliative care that the AMA today suggested would be 30%, palliative care, potential cost impost extra that we require, plus potentially extra help in aged care, which we have not discussed in great detail, noting that we have seen significant deficits in aged care facilities elsewhere, plus the potential for buildings, physical location to be able to provide VAD services standalone, albeit not building a new hospital, plus at least some FTE being a number between conversations we have had now 4 and let us call it 10 people, but less than 10. Is it fair to say that those are the costs and resource imposts that we are looking at to introduce a VAD service in the Northern Territory in the future, notwithstanding that service delivery models may vary? Dr Burgess, Chief Health Officer, I think that is not unreasonable. I think the missing component we've not really touched on in that list is the review board. Mr Chair, yes, sorry, I forgot that one. It's on my list too. It's on my list. Dr Burgess, and the pharmacy service, which might be part of your FTE. The pharmacy service would be logically centralised within our hospital network. I'll stop quoting from there. The point is that the Health Department have been clear that they would like to help provide VAD, but that they cannot do it without additional resources, and that they cannot do it by simply manipulating existing budgets. So if we are going to provide a VAD service, we cannot provide a Rolls-Royce for 20 people a year. It's just not realistic. It's not reasonable. We all know in this place that we have competing considerations when it comes to healthcare. We on the committee believe in equitable access to VAD, and we definitely are proposing that there should be legislation in the VAD space. But that's why it's so important that this is done right, as the Chief Minister pointed out today. We really are past the point where we can just introduce any sort of legislation into the VAD equation and say, we'll just use this one and then figure out the rest later. That's not going to work or end well for anyone, is the honest truth. And now, with the benefit of a report that has multi-party support, I'm hopeful that my colleagues will concur with me that we should work together, but that we should work from the starting position of utilising this report, this set of drafting instructions, this set of recommendations, so that we get the right results for Territorians as soon as meaningfully possible. Now, moving on to the body of stuff that we learnt out in those sort of bush consultations, if you like, Nooka was the first place we went, and it is a little bit scrappy, is the truth, because we are refining our technique and our consultative process. We're trying to conduct a town hall meeting with a church room full of people. Microphones are going everywhere. We're getting personalised stories, but we still learnt so much that day. And it was an excellent place for us to start our process. The Borroloola Local Authority on the 7th of August is where we first started getting really clear expressions of how angry a lot of older Territorians are about the fact that the rights of the terminally ill was taken away. And we hear loud and clear, it should never have gone, why can't you just bring it back, do something about it? And the Borroloola Local Authority were very generous in squeezing us into their timetable, their timeline for consultations, meetings within their council chambers that day. In Barunga, we had multiple stories across multiple consultations, local stories from traditional owners and senior elders about local clinics and service provision. The Barunga consultations are some of the best ones for us talking to everyday people, not through the filter of other voices, not through representatives of someone, but actually talking to people on the ground who live in the community, have an opinion and wanted to express it when provided the opportunity. Gunballunya is an extremely important set of data that people should look at, where we met on the school premises and with the principal and staff discussed really in detail some of the very curly questions about VAD. It's where we have some of the most clear-cut evidence of lived experience of Indigenous people, of interaction with end-of-life care and with euthanasia itself. Not in some salacious way, not in some criminally prosecutable way, but in a way that acknowledges our shared humanity and the fact that nobody wants to die a painful death, and everybody recognises that at the end of your life, we are all fragile creatures in need of help. Our consultations in Papunya were the largest facilitated discussion we had, facilitated by none other than Alison Anderson, a former member of this House, who was extremely gracious in running a mass community consultation, which started off with, I think, for want of a better word, outright hostility, and ended with us all learning a lot from one another. Great example of two-way learning, of us having a conversation, translating out to people, and learning about the importance of a communication strategy for VAD going forward. People who didn't have a clear idea of what we're doing, and once they did have a clear idea of what we're doing, had a different perspective on what their take on it was. To be clear, there was overarching opposition to the idea of people in that Papunya community being involved with voluntary assisted dying in its ordinary form. But there was not blanket objection. And there were important discussions that were had about palliation, about palliative sedation, about people's interaction with healthcare out there through somebody who is as fierce and knowledgeable an advocate as Alison Anderson. So at Papunya we learnt a ton again. Numbulwar is one of the few places that I'm not in a position to be able to provide personal testimony because I myself was absent that day, and I'm extremely grateful again to the member for Casuarina, Mr Kota Patel, who on 13 minutes notice availed himself to get on a light aircraft to ensure that the committee had quorum to go and take testimony. And so that's another situation of a place where we've had to be agile, where we've had an imperfect set of circumstances, but under the auspices and careful management of the Deputy Chair and the member for Wanguri, we were able to collect valuable testimony that day in yet another setting. Alice Springs, as I mentioned previously, was one of the most important places we collected data on a number of fronts. We met with the Aboriginal Engagement and Strategy Unit at the Aboriginal Hospital and really learnt about the necessity to provision for conscientious objection, not just for doctors, not just for nurses, but for what you might call healthcare adjunct workers. We had testimony from people who are essentially interpreters, liaison officers, people who engage with Indigenous healthcare through the hospital, who made it super clear to us, I really don't want to have to be, as part of my job, translating information on VAD. I really don't want to have these conversations and present this information. If this becomes a necessary job requirement for me, that is going to put me in an impossible position. And we really understood that first, best and most clearly in the Alice Springs Hospital, talking to the Engagement and Strategy Unit. We then went on to speak to the palliative care team at the Alice Springs Hospital, and the Alice Springs Hospital, under the auspices, or including the involvement of Dr Christine Anderson, who's a specialist doctor in palliative care there, the Alice Springs Hospital had already provided us a very detailed submission, which was really important in the written submission pack to look at. And we discussed that further in person, and it gave it more light. And one of the key things that we were able to take away from there was the importance of where VAD happens matters. Now, the Alice Springs Hospital and its staff and its palliative care team made clear how hard they'd worked to make sure that there is trust in that hospital, that people in the wider Alice Springs catchment area treat that hospital as a place of healing, not a place to come and die. And we want to make sure that that is maintained. And so for the people that were purveyors of healthcare in Alice Springs, including the palliative care team, it was so important for them that if and when there is VAD services, that they don't take place or don't have to only take place within a hospital setting. Now, we wrestled with the idea of whether or not to suggest that they should never take place within a hospital setting. But again, the wisdom of our healthcare department through the testimony provided in public hearings was that don't stop us from being able to do that, but it's important that we have other spaces. In the perfect world, people are able to have VAD services in the comfort of their own home, surrounded by their loved ones, or perhaps back in their communities, surrounded by their family and loved ones, back in country on place. But there are going to be instances where people are too sick to leave hospital and it needs to be done in a hospital. There are going to be instances where we need safe third-party places. And we can't build entire new VAD facilities, but we must provide for neutral spaces for people to be able to access that level of service. And it's a shame and a deficiency of our inquiry again that we were not able to get out to Nhulunbuy and Gove, where we know that there is a very good setup of palliative care existing next to a hospital with access for family and community to be proximate. And we know that that may be a model that the health department, the government may want to look into the future in terms of a best practice model for providing palliative care and aged care in remote and Indigenous settings. Returning to the Alice Springs Hospital palliative care team though, not only did we learn about the where, but we learnt there about the importance of cultural safety, about group decision-making in practice from the perspective of the practitioners, not just the perspective of people in community. We learnt about palliative care in practice, you know, what people really can do and can't do, what the limitations are. We learnt another really critical thing in relation to workforce, which is that PCAs, patient care assistants, which are much maligned in our system. A lot of the time people just think that they're not quite proper nurses who just go and get tea and biscuits. Well, they're a whole lot more than that. And in relation to end-of-life care, palliative care and healthcare, they're super important. And we explored the fact that more patient care assistants would be extremely valuable for our healthcare system. Now, why is that important? Because frankly, they're easier to get, cheaper, and not entirely ubiquitous, but they are not a precious commodity in quite the same way as a nurse practitioner is. So if patient care assistants can be part of helping us work on problems within our healthcare system, then that's a really important finding as well. And one of the other things that we learnt about was it's one thing to have people out bush say, nah, I don't want any of that treatment. It's another thing to have palliative care teams talk to you properly about people's pain tolerances and thresholds. And you know what? A lot of people out bush are seriously hard as nails. And they do say, no, I don't want anything. I will die a natural death. I believe I should die, whether it's because of cultural reasons or religious reasons. Suffering is a part of the human condition. And that's a really important thing to hear from a palliative care team. We then went to the Alice Springs Baptist Church, and I would encourage you all to have a look at that testimony because it's one of the, it was such a good example of legitimate, reasonable, measured objections on religious grounds to VAD. We had the benefit of hearing from the pastor there who made it extremely clear to him that he believed life was sacrosanct and that VAD was not something he would ordinarily endorse for. But when we pushed him on the point, when we asked for him to provide specificity, and I'm going to quote from page 6 of that testimony on Thursday the 21st of August in Alice Springs at the Baptist Church, Mr. Brown, quote unquote, as a pastor, my responsibility is to meet people where they are at. So if somebody chose that path, i.e. the path of VAD, I would not necessarily endorse it, but at the same time I would be there with them 100% of the way and help them to discover that God is present within it. I do not think that the church would simply remove, or I hope not, themselves from that space just because it makes them uncomfortable. The church has a responsibility to meet people where they are at from my perspective. There are balanced and nuanced and reasonable objections to VAD from people on a range of grounds, and you will find them if you look at the testimony, and you will find them if you go through the witness transcripts. In that same vein, we met in Alice Springs with a representative of the Australian Christian Lobby. Now, the Australian Christian Lobby is in many regards often maligned and perhaps unfairly so on occasion. And I think this testimony again is worth looking at in that regard because what it offers is clear-cut opposition to VAD, no doubt about that, but it offers a considered, reasonable set of conscientious objections on faith-based grounds. In the competing rights and priorities of the healthcare system, the witness on that occasion makes clear that his priority would be for us to do much more in palliative care rather than to put our efforts into VAD. Now, we as a committee, as I say, believe that more should be done in palliative care, but also that people should have equitable access to VAD. But I think it's important to understand that we haven't just put together a rubber stamp, glossy report without really hearing what Territorians have to say on this issue. And that doesn't mean we've agreed with everything that they've had to say, but we have tried to weigh all of the data and make careful, considered decisions about what might be a reasonable, practicable way forward. The Old Timers Aged Care Centre in Alice Springs, again, was a really good example of two-way learning, where we were asked a very basic question by someone in the audience about, so what percentage of people support VAD? To which we were all slightly flummoxed because we were like, actually, we don't really know the answer to that question. We're not here to run a referendum, and it's important that we collectively all start figuring out the answer to that question. The other interesting thing there was, again, to have somebody actually say, why do we have to call it VAD? What is VAD? I don't even know what VAD is. VAD sounds so insensitive. Why can't you properly call it voluntary assisted dying, given the seriousness of it? And that's one of those things that fed into us trying to understand, you know, why the rights of the terminally ill might be the right nomenclature to use in this regard. And I don't want to take away from the importance and significance and weight and gravity of this discussion, but I will point out that VAD, VAD, voluntary assisted dying, was still so confusing that we genuinely have on record testimony from an elderly gentleman who turned up thinking that the consultation was about dying wool, not about dying people. He genuinely turned up to tell us, I didn't realise, I thought this session was about wool dyeing. I actually just want to live for as long as possible. Thanks very much, see you later. So nomenclature, words actually matter. I mean, I'm being pithy with the observation, but in all seriousness, words matter. How we describe things matters. Definitions matter. One of the important things, two of the other important things that we learned from that session were, that was a session where we had ex-Victorian nurses in that facility who basically straight away asked us all the hard questions on, I was there when this happened in Victoria. I remember being gagged. I remember all the angst surrounding whether I was allowed to speak or not allowed to speak or could refer anything to anyone, or family members saying you're not allowed to have that conversation with my elderly father or mother. Those are the questions that need to be resolved from the front end. And so initiating the conversations is something that we, in our report, have strongly lent in favour of. Our report is not a libertarian report, but we have fundamentally tried to prioritise transparency and openness and to allow as much of the information that we've collected to see the light of day. And to that point, we want for healthcare practitioners and medical practitioners and people adjunct to the healthcare process to not be inhibited from having conversations, even if that conversation is one that says, this isn't for me, I don't want to be involved, but the minimum expectation is, here is the number of the VAD Navigator service. Here is a connection to somebody who you can talk to. Return to country programs were also something that were discussed in that space. And again, they're really important to understand that there are already, under the auspices of community health organisations, programs in place to help people who are elderly, infirm, and often terminally ill or in the last stages return to country in some form. Not necessarily to provision them to pass on country, but at least to connect to country. So there are some existing mechanisms there for us to work in parallel with so that we don't reinvent the wheel. We simply don't have the money to, you know, quadruple what we do in patient travel assistance or in care flight or whatever it might be. So we have to be agile about thinking how we can provide equitable access. And again, something like a return to country scheme already exists for us to be part of. The final of the four major sweeps of areas that we covered, as I said, was the Barkly, Tennant Creek region. And in those places, we learned extensively about the aged care sector, about the significance of moving to ARCHOs, even things like self-care dialysis and the viability of it, and about pharmacy control of VAD substances. That's a clear place where somebody who is involved in pharmacy services has said, we really do not think it's a good idea to have these substances in our community for any longer than necessary. And so it's important for people to understand that even a decentralised VAD service would require centralised pharmacy services to ensure the safe supply, storage, use and disposal of pharmacological substances. So beyond the Barkly Regional Council and meeting with the folks there, we again got to have a look at yet another aged care facility in Pulka Pulka. And that was a great opportunity to talk with a gaggle of nurses and hear their real stories about their concerns about having indemnity from liability if they were to be involved in things, protection for carers, palliative care services as they're provided, and again, visits to country. They were able to provide us with stories of agility in helping people out. In Tennant Creek, in community consultation drop-in sessions that again we were able to arrange, we learnt about disability, dementia and terminal illness from people in disability advocacy. And that was really important to understand as well, because we weren't able to cover, as I said, every aspect and nook and cranny of respondent that we might have liked to cover. But we have a good representative data set and sample, and it is not to be underestimated. It is a lot to suggest that in 300 pages of reporting and with an appendix and drafting instructions, one should still refer back to the source materials. But the fact is, the real meat and potatoes is in these source materials, in these witness transcripts out bush, in these written submissions, 400 plus of them provided by Territorians from all over. We had further consultations on the back end in Tennant Creek as well, with the Cattlemen's Association, with individual people, with the Tennant Creek mob. Some of those transcripts are still not publicly available. And again, I say on the record that that is unfortunate and imperfect, but the necessary, the result of the fact that we have done this under compressed circumstances and timelines. And so I commend again the people who have helped us to output this work, being not just the committee secretariat, but for example, Parliamentary Hansard, who have had to work around the clock to essentially churn out all of these transcripts for us over and over again, for us to try and read, process and publish safely as expeditiously as possible, to ensure that today people will have the opportunity to discuss not just the report and the finished product, but to discuss the raw ingredients that inform that finished product and to learn from that, to cite from that, to quote from that. So nothing has been hidden at any stage. Everything has been as transparent as we could reasonably make it. And our priority has been, as I say, to progress the agenda of VAD. Now, this would not have been possible at all without the committee secretariat, and I thank them all for their enormous efforts in trying to meet our timeline. But I also want to thank individually and specifically the 5 committee members, all of whom put in a significant amount of work to making this happen. I am grateful to the Deputy Leader of the Opposition for helping to provision access for us in many Indigenous spaces and for being a willing participant in the conversations, and for also the robust discussions that we were able to keep within the confines of meeting spaces. In a similar vein, I am grateful to the member for Nightcliff, whose worldview and mine don't align in many regards, but who was very diligent in trying to prosecute her case and to have a contest of ideas and to maintain, to hold her ground, but also to cooperate with us as a multi-party committee to produce a unanimous report. Above all, though, I really do owe a debt of gratitude to my 2 government colleagues on the committee, the member for Wangari and the member for Blaine. And I single them out not least because they were there for all of it, the hundreds of hours of all of it. Even I must confess, as the chair of the committee, that I missed 2 of the sessions for illness. They were there for all of it. They were there for every meeting. They were there for every consultation. They were there for every hour of every minute of all of the hearings. And they took the time, as with the others, to get across all the materials as best they could, and certainly demonstrated, as is evident through our minutes and through our inquiry testimony and witness transcripts, they were prosecuting the agendas, asking the hard questions, and trying to really dig deep and get answers. So I'm enormously grateful to both of them for their time in that regard, and also separately to the member for Blaine as the Deputy Chair of the committee for deputising for me on those occasions when I was unavailable, because it's not easy to get thrown in the deep end on something like this when you're suddenly the one tasked with trying to build a bridge in a foreign place on a very complicated topic that nobody actually wants to talk about. So I thank again the member for Blaine for his sincere effort in that regard. Most especially, though, I want to reserve my real thanks, my final thanks, to those who have generously shared their time and shared their stories with us from across the Territory. It is not an easy thing to talk about the death of a loved one at any time, even when it's a historical issue. It is not an easy matter to discuss, the harsh realities of palliative care and end of life. And people did not have to speak with us. There was a better than even chance that we were going to arrive at a lot of destinations with limited notice and suddenly find ourselves eating sandwiches sitting on the red dirt with no one to talk to. And that never happened. And that never happened, not once. Everywhere we went, people came to talk to us. The Secretariat were extremely diligent in setting up people for us to get started with. And then by a combination of luck, design, cooperation, collegiality, commitment to the cause, word got out that, we were available to have a yarn with people if people were interested in having a yarn with us. And we did manage to capture a significant amount of testimony, huge amounts of testimony, quite frankly, in the time that we had available to us. No research process, no consultation, no inquiry is ever perfect. And I freely admit on behalf of the committee, for the sake of the committee, taking ownership of the issue, that this inquiry was replete with imperfections. But for all its imperfections, we have produced a report that is of high quality. We have a large catalogue of evidence now, which people will, at their time and discretion, have the opportunity to be able to interrogate, to understand the totality of what we have learnt on VAD. And I believe that we have satisfied the core goal that was always at the forefront of my mind, which was not to decide on VAD, but to provide progress on the issue of voluntary assisted dying for Territorians. Now, I have, as everyone is aware, erred on the side today of completeness to cover the field. I have done so advisedly, but I'm grateful for the indulgence of my government and my government colleagues, and likewise to the opposition leader, the deputy opposition leader, and members of the crossbench who have been willing today to afford myself as the chair of this committee to make a substantive tabling statement. I have done so because I believe that this is an important issue that Territorians have been waiting 30 years for real progress on. And finally, together, collectively, we have the opportunity to present that we as a parliament can move forward on this issue for the benefit of all Territorians. As chair, I simply want to say again, thank you to all of the people who have participated in the inquiry in any form. I'm extraordinarily grateful to my committee members and likewise to the Secretariat, the Hansard, the parliamentary staff, all of whom have been instrumental in making it possible for us to achieve a result. My final plea in my capacity as the chair of the Legal and Constitutional Affairs Committee, and my duty as I see it, is to ask the House in earnest and to implore the government of the day, and for that matter the opposition, to work collectively now to ensure that the bill that we hope will come to this House in due course will reflect this final report and will reflect these drafting instructions with consideration for the recommendations of the report more generally. Mr. Speaker, on that note, I move that the report be noted.
Thank you, Member for Fong Lim.